Once again, welcome to the Power of the Voice. My name is Brandon Terry, and I would like to thank you for joining today's presentation, Equal Opportunity for All, Building a Culture of Respect. Darren Dante Bonner holds a bachelor's degree in Business Administration from the prestigious School of Business at Florida A&M University. He has over 25 years of experience in civil rights and employment law, serving the Florida Commission and Human Rights in areas of customer service representative, mediator, investigator, and customer service intake manager. He currently serves as the Educational Outreach Training Coordinator, where he is responsible for providing educational outreach for the citizens and organizations in the state of Florida. Mr. Bonner holds credentials for the prestigious Lean Six Sigma Green Belt certification. Mr. Bonner is committed to ensuring that all citizens receive the highest level of knowledge and information to be effective and impactful within their community. His philosophy is that all people, regardless of gender, ethnicity, age, or belief system, should have the right to live peacefully amongst all individuals and enjoy life with the utmost without being subjected to discrimination. Please welcome Mr. Darren Dante Bonner.
It doesn't matter which mic? Okay. Good morning. Can everyone hear me? How's everybody doing? Well, first of all, give yourselves a hand for coming out to participate in this summit. We want to give recognition to the City of Tallahassee Mayor John Daly, for hosting this, and I also want to give recognition to my Executive Director, Ms. Cheyenne Castilla of the Florida Commission on Human Relations, and the Chief of Investigations, Ms. Jacqueline Dupree, who I work along with in this presentation. And I know he does not like this, but I'm going to give special recognition to one of my colleagues that came from the Tampa EEOC office, Mr. Borges, Carlos Borges. I just want to give him a shout out to him. We work along together. I'm also with the EEOC director, Miss Evangeline Hawthorne, who is over the Miami District office. So we have our federal relationships here. So I just want to give recognition to that as well. So what we're talking about today, equal opportunity for all and building a culture of respect. First thing to do, I do not conduct trainings. Let's get that clear. I conduct conversations. Trainings are boring. You say, oh, Lord, this ain't gonna be over with. I'm so tired of this. I'm hungry. You know, did I leave the greens on the stove? I got some work to do. I got the report due at 5 o'clock. Yeah, we don't do trainings. We do conversations. Conversations allows us to have dialogue. Conversations allow us to be able to think. And we're not going to always agree on the same thing, but at least as the gentleman, Mr. Rick Caldwell, said this morning, we'll give it the opportunity to think and look at different perspectives. And I like that. That builds into my philosophy as well. So one of the things we're going to talk about today is who we are, the Florida Commission on Human Relations. We're also going to talk about equal opportunity laws. Now, we're not going to go over every last one of them. There are too many to name. We're just going to highlight just some major different things that both as employees and employers that people we need to know. Then we're also going to talk about the Americans with Disability Act, commonly known as the ADA, and some what I call nuggets to know, little tidbits to help you along your way as you continue your business and work journey. Discrimination. How many of you all have heard that word? I'm going to ask a question. What is discrimination? And this is an interactive part of the conversation. And just like your teacher, if you do not raise your hand, I will call somebody out. And I do believe we have another mic here. Tanzanisha, my fellow colleague, if you can come and assist me with this mic here. They want to make sure we're recording this. So as persons are raising it, if you can help me with that. This is my colleague, Legislative Affairs, Ms. Tanzanisha Collins. So she'll be assisting me as well. So what is discrimination? I want to hear something. Saw this lady here in front and then the gentleman in the back. Could you raise your hand, ma'am? Yes, that. What is discrimination?
Someone looking at you because you're different in some way.
Okay.
Difference.
All right. The gentleman back here in the back.
The opposite of being treated fairly.
The opposite of being treated fairly. All right. Anybody else? What is discrimination?
Discrimination is judging someone based on their race or culture and preventing them from doing something based on their race or culture.
Okay. Great answers. Great. We have a gentleman up front here. Preconceived assumptions. I like that. Preconceived assumptions. Look at all the various different aspects of discrimination. When we say the word discrimination, most of the time we're thinking about, as the woman said in the back, race and color and preconceived assumptions. But I also want to challenge you to expand your thought process on the word discrimination. The treatment of a particular person, group of people, differently in a way that's worse than people are usually treated. And the practice of treating people, companies, products differently, especially in a way that's unfair. Now, if you notice, it's not talking about anything specific. It's just talking about just being treated differently. So I'm going to give you an example. How many of you all love ranch dressing? Raise your hands. Raise your hands high. Ranch dressing. Ranch dressing. Got my wings in front of the game, dipping in my ranch sauce. I can't stand ranch dressing. So, all of you all that said you like ranch dressing, I'm not hiring you. Have I discriminated against you? Why did I discriminate you? But I don't like ranch dressing, so it shouldn't matter that you like ranch dressing. So it's what I want, right? Now, if you didn't get hired because of ranch dressing, is that right? How does that make you feel? Okay, you guys speak a little louder. Angry, disappointed, hurt, all because you like ranch dressing. Now, here's my question. Is it unlawful that I didn't hire you because you like ranch dressing? Come on, let's talk about it for a second. Is it unlawful if, think about the question now before you answer. Is it in the law that if I don't hire you for liking ranch dressing, can you file a complaint that you weren't hired?
No. Yeah.
Yes.
If you were hired.
I love this. I love this. I love this. I love this. Let me help you out. It is unlawful if it's in the law, but there is nothing in the law books that says you're being discriminated against because of ranch dressing. So, we're talking about there is a difference between discrimination and unlawful discrimination. And one of the things about the Florida Commission on Human Relations, we deal with unlawful discrimination, and we're going to talk about what those areas are. And the reason why I want to bring up this conversation is because that word discrimination is a very heavy and powerful word, and it is true. You have been hurt, you have been minimized, you have suffered some type of not being hired, any type of adverse action is what we call it. That's the proper term. But you've been hurt. I didn't get my job, I didn't get promoted. They sent me somewhere I didn't want to do. I've been retaliated against. I've suffered some type of harm, all because of some type of protected activity or something that I felt was close to me. And one of the problems and one of the challenges, not just the Florida Commission on Human Relations, not just the Equal Employment Opportunity Commission, not just the City of Tallahassee, but trying to understand the fact there's a difference between being treated differently and then what is lawfully being treated differently. All right? So we're going to talk about the Florida Commission on Human Relations. We are the only state agency in the state of Florida that investigates allegations of discrimination. We were established back in July 1st, 1969. Now, what's interesting about this is the Civil Rights Act of 1964 was only created a few years prior to that. So we were created a few years later with 3 employees. As of now, we have a total of about 60 for the entire state of Florida, from Key West to Pensacola and all points in between. Very lean, where we have a lot of responsibility. One of the things about the Florida Commission on Human Relations, we have partnerships. As I stated before, we have partnerships with our colleague, Mr. Borges, with the Equal Employment Opportunity Commission, also known as the EEOC. Now, everybody's heard of the EEOC. And also, we also cover housing discrimination, which I will talk about just about for coverage, with the Housing, Urban, and Development, which is also known as HUD. So, I just explained to you about unlawful discrimination, right? So, for the Florida Commission on Human Relations, there are 4 areas that we have coverage and protection on. And these are the areas. We have employment, housing, certain public accommodations, and state whistleblower retaliation. Now, state whistleblower retaliation is basically for state employees or that have filed a complaint as a result of blowing the whistle, and they've suffered some type of harm. One of the things that we also cover, mediation. Then we have education outreach, me. I didn't want to put my name there, so I just said education outreach. But that's what we do. Our job is we are a neutral agency to not only investigate allegations of discrimination, but to also assist the public, which includes the businesses, the organizations, and the citizens, to let them know what their rights are. We don't have a gain. We don't get any extra money. We don't get nothing out of whether we have discrimination or do not have discrimination. But our job is to make sure, as citizens, make sure you know your rights. Make sure you know what your responsibilities are. For employers, what you don't need to be doing, and to make sure you follow your guidelines and perceptions. So this information is to educate and to empower everyone to make sure you know what your rights are. Okay? So let's talk about the EEO laws for a moment. So for what our agency covers, we have jurisdiction for the federal and the state level. So the federal laws that we deal with are Title VII of the Civil Rights Act of 1964, Americans with Disability Act, ADA, which we'll talk about later on in our conversation, Age Discrimination Employment Act, also known as ADEA. So those are all the federal laws that we cover from the employment aspect of it. Then we have our state law, which is mirroring our federal laws, which is Florida Chapter 760, which coincidentally also established what our agency does. Then we have Florida Statute 112, State Whistleblower Retaliation. What's important to know these laws is we just didn't make these up. We just didn't decide, think I'll decide, make a calls on this one, think I'll do calls on that one. Now, these are our guidelines. So what this means, this allows everyone to have the opportunity. You can go and read for yourself to see what we cover and what we don't cover. Now, as with everything, there will be difference of opinion, because when you file your complaint, I should have been given a cause. Well, based upon the facts, maybe not. And that's on both sides of that. But this is what governs us. This is what gives us the authority to be able to look into why or why not did discrimination take place or not. So, I just told you about unlawful and lawful discrimination, and it's based upon a protected class. Now, that's a fancy word. What is a protected class? A protected class is basically who you are as a particular characteristic. In the example that I gave you, your protected class is ranch likers, ranch lovers, ranch dressing, ranch sauce, ranch whatever. So, but here are the areas that Chapter 760, which is our state law, and Title VII of the Civil Rights Act of 1964 covers. These are the protected bases that if you feel like you've been harmed, you can file a complaint, which is race, color, religion, national origin, sex, and this includes the subsections of gender identity, sexual harassment, and sexual orientation, age, disability, retaliation, and here's the one that people don't mostly know: marital status. And that's a state-only claim. Now I'm going to break these down to you to make sure everyone understands when we say all of these particular things, what it means. First of all, race. Now, the classification that I see here, I did not make this up. This is coming from the federal government, from the OMB office, Office of Management Budget. They have established based upon a social perspective, not a scientific one. So if you all are mad about what the classifications are, please contact your congressman and local government and let them know that you would disagree with that. I'm just repeating what they told us. So, the first one is black, white, and it's in no particular order, by the way. So, black, white, Asian American or Indian, or Alaska Native, Native Hawaiian, and other Pacific Islander. That is based upon the facial classification of race. Okay? Second classification is color. Various skin tones or complexions regardless of race or national origin. And we typically see those in the African American community, the Caribbean culture, the Hispanic culture, as far as the hues of different individuals based upon the fact of how light or how dark someone actually is. And the interesting thing about, as far as the word black is concerned, one of the things that you all realize is there are a lot of terms that are constantly evolving. And for example, for the word black, you know, years ago, it was called colored. Then it went from colored to Negro, then to black, then African American. So wherever you on this perspective for the African American community, that's how you might identify with. So I have a question. Yes, ma'am.
Hispanic is not listed. Is that because it's considered an ethnicity versus a race?
Yes, it is. And I will follow up with that question as well, because I want to add to that. Hold up, but hold that to that rest of that question. But the answer is yes.
I'm held.
Yes, you're held. I'm going to hold you, okay? All right. Religion. Religion, real simple, a sincerely held religious belief, observance, or practice. When I say religion, are there any other type of religions that you don't think would fall under this? Or is it talking about all religions? Very good, very good. If I had some money, I'd give y'all all a little gift card to Chick-fil-A. Yes, even if you believe in spaghetti God. Religion is dealing with all religions, all particular beliefs, traditional. So whether it's Protestant, Catholic, Jewish, Muslim, Baptist, Presbyterian, Pentecostal, Baha'i, and the non-traditional ones, Wiccan, snake worshipers, naturalists, Scientologists. This also includes atheists and agnostic, if you don't believe in God, or you believe in multi-gods. I serve you on Monday, serve you on Tuesday, serve you on Wednesday. And it's not predicated on if the employer believes that you have that sincere belief. So if you were saying, I am of a certain religious belief, and your employer says, no, you don't, because you do such and such outside of that. Doesn't matter what the employer says. I remember I had a case one time that I was an investigator for 14 years before I moved up into management. And the employer says that, well, how can they be a Muslim because they eat pork all the time? That was their defense, that they didn't believe. It doesn't matter. It is the sincere religious belief on how they were being treated because they were observing prayer 5 times a day. But because of that one little different aspect that they thought they knew, that's why they treated that differently. You can kind of guess where we kind of led to that on that particular case.
What if I say about this?
It doesn't matter. The focus is when you're talking about a protected characteristic. I am alleging that because of who I am, if I'm a Baptist, that they treated me differently for whatever particular reason. And it was treated differently for somebody else who was similarly situated to me. And then we as an agency look into, did they unlawfully treat you differently because of their reason and not for another reason? That is the lens on how investigations are looked through. Okay? Next one, national origin. We're back. So we have two perspectives from national origin. The first one is country of origin: Nigeria, Australia, Japan, Egypt. You name a country, we cover it. So that primarily deals with a lot of immigrants that come into the country. Interestingly enough, you do not have to be a citizen of the United States to file a discrimination complaint. That's a little caveat there. So illegal immigrants, if they are working, they still have the right to file a discrimination complaint. Now, we understand there's a fear because of other things that go along with that, and we don't get into the political aspect of it. Our responsibility is if you allege that you have been hurt and harmed, we investigate that. The other aspect is ethnic or cultural background: Hispanic, Middle Eastern, Jewish, Indian. So the question was raised as far as Hispanic was not listed as a race. One of the things that our office and our fellow federal partners also do, we recognize the fact that, as I stated before, the government has a social perspective of what race is, and we acknowledge that. But when an individual who says, I'm Hispanic and I feel like that is my race, we're going to take what they said as that is their race. It is not our job to say, no, you can't do that. The paper says this is not, no, we can't do that. So when you come to us and says, I have been harmed because this is how I identify, we're going to take what you said, because it doesn't change the scope of what type of investigation is being done. All it's doing is basically saying this is the characteristics that we're going to look into. All these are just classifications. You're in the number. That's basically what it's saying. How it's classified, that's just a social structure. But it's important to know that it doesn't change the identity of who you are. It's not our job as the state or the federal government to tell you who you are. These are just saying these are the characteristics that we look into. And that's a difference that everyone needs to understand and be aware of. We also cover sex. The most obvious one, male, female. This also includes transgender and gender identity. Okay? Sexual harassment. Sexual harassment from 2 points. One, being harassed, being subjected to a hostile work environment. So that means when you're going in and they say, hey, baby, how you doing? Well, okay, I'm fine. Hey, baby, how you doing? Okay, fine. Hey, baby, okay, look here. Tell me that 3 times. Leave it alone. Well, what's wrong? I just give you a compliment. Okay, Mr. Manager, he needs to leave me alone. You're being harassed. Now, I didn't say anything derogatory, perverse, but because it was an unwanted attention based upon their characteristic, that could be harassment. And it goes vice versa too. Even though it's not reported, men can be harassed as well. Baby, you sure looking good in them jeans. I appreciate it. No, I'm serious. Men don't normally look like that in those jeans. I appreciate it. But most men, we go like, I appreciate it, girl. You know what I'm saying? You know what I'm saying? I like that. What's your name? What's your name? Mary. But harassment does happen. Okay. Also, if I come into a conversation in the break room, man, I hit it up last night. They were up and down the pole and everything. Like, I don't want to hear that. Well, go someplace else then. Well, I'm in a public space. I have a right to be here. Well, then you just need to listen to what we're saying here. That could be subject to harassment because it's in a public area. Even though it was not talking about you, I was talking about what I saw last night on the pole. But that could be harassment at the job. Here's another thing. If I'm in my office and I come and talk with you, yeah, how you doing? Why is Chippendales all on your wall? Well, you know, my girls, we went to Vegas and it was girls' night and everything. And, okay, yeah, but I really don't want to see him in his cowboy hat. It's my office. Okay, but I got to come in here now. That could be harassment too. I break this down because we have a very finite view sometimes of when we say sexual harassment, it's mostly a man is mistreating a woman in a very provocative manner, and that's harassment. But harassment is much bigger than that. And we perish for the lack of knowledge and understanding. So our job is just to educate its nuances. And one of the things that we have a problem with is nuances. We look at things very linear. If it is not A plus B equals C, then it didn't happen. And so when we do things outside of A, B, and C, it's like, well, I don't understand. Well, how is that? Because you're looking at it from a finite perspective instead of a very broad perspective. And then the other aspect about sex is sexual orientation. Now, this is a very controversial topic, but we don't get into the controversial aspect of it. The other thing that we want to acknowledge the fact this was basically as a result of the Supreme Court case of Bostock versus Clayton County, which is back in 2020, that established the fact that sexual orientation is a form of sex discrimination. Now, here's the thing you need to understand when we're looking at this. This has nothing to do with our personal beliefs or opinions. All we are looking at the fact is legally, they have a right to exist. You have a right to exist. And were you harmed because of who you were? Point blank, period, full stop. Has nothing to do with the fact of, well, I don't think that's right, or they should have the right. Our rights don't matter as far as our belief system, as far as doing the work. But this is what's covered. And that's one of the things that you have to understand about the agency. Personal belief systems do not play a factor into that. They can't. Then all of a sudden, we're going to be in the hot seat talking about, why the facts say this. But well, I don't think it's just right. That's not your place. And you will get corrected, and you will have to seek other means of supporting your loved ones and those wonderful little children you have. All right? Yes.
You talk about harassment with sexual incident. Is there harassment tied to the other pieces? So, we'll use religion as an example. You know, if you talked about going into the office and there's Chippendales all over the wall and the uncomfortability. What if you go into somebody's office and they're, you know, you talk about religion, they're a devil worshiper and they've got the upside down star and everything else and pictures of Satan himself hanging all over the walls. I mean, and that makes you uncomfortable. How does that flow?
Yes. Harassment is one of those issues that goes across all of the spectrums of protected classes. Particularly, we see a lot of times as far as harassment is on the sexual nature, but harassment is as far as with your race is concerned, making derogatory comments. Harassment based upon your religion, you know, there you go, wearing that thing on top of your head, that little whoopee, like whoopee, it's called a yarmulke. You know, or, you know, like, hey, don't you want to have some pork? Why you keep doing them? You know, I don't observe eating pork. Or those type of different things. The work environment is not a place for you to tote your personal beliefs. It is a professional work setting for you, as Mr. Caldwell said, to get the mission that you were hired to do. Now, we don't divorce ourselves from who we are. That brings diversity into the place. But the purpose is, I did not come here to spout my personal belief systems. I came here to open the mail, date stamp it, and make sure it's in the mailbox. I don't need to highlight the fact that, yes, I'm a tree hugger, and I'm putting mail in the... What does being a tree hugger have to do with me doing my job? Now, what you do outside of your work hours, that is your own private time, and that's fine. And it doesn't divorce you as your belief system, but doing the job itself, where your rights in another person's begin. So we don't have the right to impose or enforce our personal belief system in the workplace because there's so many various different things. Now, on the other side, man, y'all making everything so hard. Can't do this, can't do that. But you weren't hired to have a good time. You were hired to do a job. Now, we want to make sure we all getting along and we're happy and we get along. And there are certain common things that we can all get along with. But as soon as you start infringing upon the personal rights and characteristics of another person, that's when the workplace starts becoming harassing. And where we're covering is all these particular areas. We're talking about age now. Yeah, old man, I heard you about to retire soon. I'll be glad too, because you've been holding that position for too long, and I need that position because you got the best work hours. When you gonna retire? You know, y'all old people, y'all just move so slow. Y'all don't do things right. I am harassing you. So harassment covers the gambit. So keep that in mind as well. So when we're talking about age is failure to hire or discharge any individual with respect to their compensation, terms and conditions, privilege of employment because of how old you are. Now, when we come to age, there are two areas I want to highlight. Under the federal government, which is the ADEA, that covers individuals 40 and older. So if you feel like you're being discriminated against and you are age 40 and older, you are covered federally. I want you to speak to the mic on this one. Won't say it. Say it.
Am I to understand that age 40 is considered old?
Okay, I'm gonna walk this line right here. Okay, I'm gonna give the professional answer. No, age 40 is not old. When this law was created, they just came up with a nice little number to make a distinction from one side of the group to the other side of the group. Now, if you would like to know why age 40 was that, you would need to talk to President Bush and ask that particular question when they approved the ADA Act. And so he will give you more clarification as the number 40, because I'm in that category as well, and I don't think I'm old. I mean, I can still bend down and, you know, do all like this. So, but stop it. So how they came up with that number, I can't answer that question. Yes, ma'am.
I just look at it from, wouldn't it be a good thing that you're covered? I mean, regardless of if you're classified as old or not, I mean, I'd just be happy to be included.
That's a good point. I think one of the things that we have to understand is the federal government makes certain rules and guidelines, and most of these things, and I want to make this very clear, it doesn't change whether the fact you have rights. The federal and state level is basically for the purpose for legal purposes. So when you want to file in court, which avenue are you going to go in? Federal court or state court? That's really the purpose of it. You're still harmed. It doesn't lessen the harm if it's only covered by the state or if it's only covered by federal. It just gives you the option as far as if you want to expand on taking your complaint further. But it doesn't change the fact or take away that, oh, the federal government did it, oh, I got more power. No, doesn't take that. Oh, the state did it. I got more power. No, then neither. It's just for purposes for legal aspect of it. But as far as investigation is concerned, if you were harmed, you were harmed. Regardless, it's the fact that if it was classified over 40 or under 40. I saw a question in the back. Oh, no, I'm sorry, up front and then in the back.
So going back to the age harassment, a situation where an employer continues to tell the employee, you can't keep, you're older, you can't keep up with the younger employees, I need you to keep writing you up for that, and then eventually you get fired.
Okay, so it is important to make sure that an employer does not create a hostile environment for an employee. That's number one. Number two, an employee should be disciplined based upon what is the policy in that office. But if they are using a protected class as the sole motivation reason for that disciplination, then they may find themselves in hot water. And I'll just leave that right there. I saw a question in the back. Can you help me out with that?
Well, I just wanted to make a comment about the ADEA and the age 40 and older. If you think about now, in this day and age, in this economy, that's even more important because people who were at home uh, have been had to come back out into the workforce, whether they were there raising children or because they had to take a break for whatever reason, or having to go back into the workforce after retiring. So having those protectors in place is very important so that people are not discriminated against because everybody wants a job. So you might see a person age 40 or older working in a job that you would think in your mind is more suitable for someone younger, but it's a job, so it doesn't matter. So that person, regardless of age, might want to go for it, but they may not get hired because the person that's doing the hiring doesn't understand that the rules of who should be working or who shouldn't be working, or missing opportunities or what have you. So anyway, I think it's really important that we have that in place because sometimes as older people find younger bosses or younger supervisors may be wanting to hire people that are at their energy level without giving a person older a chance, and not meaning to discriminate but just trying to build a team. So those things are very important at the federal level. And at the state level, under chapter 760, birth to death, people being able to work within their state to make those complaints, so that awareness, I think it, more than anything, it's an opportunity for awareness on the state level, so you don't get to that federal level because it's way worse up there. That's when it's real bad. So anyway, yeah, but I think it's very important, and I didn't really look at age discrimination until I got a little older and had to apply for a job anywhere they were hiring. And I may have met some of those barriers without really realizing, without really putting my finger on it. You know what I'm saying? But it happens, and so that's why we have that law. That's why it was created, because it happens.
I would say that age discrimination is probably one of the most silent things that you don't realize that happened until, wait a minute, did they just not hire me because? And I will also comment the fact of employers are missing out, because I'm aware of several entities where their aged employees, quote unquote, are doing so much better in quality of work of the younger employees, because they got knowledge, they got insight. You know, they about trying to do their business. They ain't trying to live their life by trying to do their work. You know, so that's the. Give her a hand. Come on now. Give her a hand.
So it just shocked me to see age 40 in the federal law, because you're not considered a senior citizen until you're 50, and then you don't get your discount until you're 55. So we just have a lot of incongruence, if that's the word, in our laws. So that's the only reason I mentioned it, for sure.
Yes.
Yeah.
To see this point, and I'm an HR director, so we have, when you talk about age, I hate this thing, when you talk about age, a lot of people don't know that 40 is that kind of magic number. There are a lot of things that happen at 40, and when this law was enacted back in the 60s, a little bit after Title VII, it was because at that time we weren't living as long. And when they saw someone at 40, they were like, oh my God, this person is going to need this, and they're going to want retirement and all these things. So this was a protector for businesses or for individuals to say, hey, wait a minute, just because I'm over 40 does not mean I'm not useful, that I don't have things. And then I will tell you that we utilize this word that we don't even realize we're discriminating against someone. When we say someone is overqualified for a position, we're immediately discriminating against that individual because of their age. When we're saying, oh, well, you're overqualified for that position, well, what does that mean? And so that's one of those things that to the young lady back in the back, when she said, hey, I'm filling out this application, it doesn't matter. That's why that law is there, because when, as an HR director, if I hear hear one of my managers say, oh, well, I don't know why they applied for this position, they're overqualified. No, they have unique qualifications, and they may have a little more experience, but anytime anyone applies to any position, they are new to that position regardless of their age, and they're going to need training regardless. This person just happens to be seasoned and can give you some more things.
I think I saw, was there another hand? I want to make sure I addressed everyone. So to your point, yeah, that's the age that they have developed for the federal level. And then on 760, birth to death. And it's important to highlight this because while we're talking about persons age 40 and older, we do want to recognize that younger persons do get discriminated against. Hair, different. You know, I'm 23 years old and I'm trying to get a position, and you gave it to a 35-year-old because you ain't gonna be disciplined. You know, you still out there trying to go clubbing all night, and I'm like, wait a minute. My qualifications, I got a master's, I got this, I got experience, and the fact I've done the job before. The person you're hiring ain't never done the job. So when we're talking about age, I want us to keep in mind it's not just older persons or persons of a certain age. I'm gonna have to, I appreciate it, I'm gonna correct my language. Persons of a certain age, it's not older persons. But anyone, and when we're talking about age, it's a case-by-case scenario. We're not talking about a 25-year-old was discriminated against with a 24-year-old. So let's be clear with that as well. Or I'm 45 and the person is 46. So when we're talking about age discrimination, we're talking about there is such a wide range of, like, the reasonable person, if they look at the same criteria, would they come to the same conclusion, like, you know what, they're the same, so why did you select this person? This person is 60, this person is 43. Maybe, maybe not. It just all depends. Disability. This is probably a very popular one that we hear about. Interestingly enough, when we're talking about disability, physical or mental impairment with substantial limits one or more major life activities. I'm going to talk a little bit more about ADA further on in our conversation. But a lot of times, the disability discrimination that we're looking at is dealing with a lot of mental. The physical disability, most persons, because they can see it, they will kind of handle that. But when we're getting into the mental aspect of it, that's when we see a lot of complaints. And a lot of it's because of the fact the employers don't believe you. Or you're just trying to just use this to get out of work. Or I ain't got the time to be trying to deal with this. I don't have time. So that's from the perspective of that. And when we're talking about disability, not just physical impairment, mental impairment, record of having an impairment. For example, you had cancer. You went to treatment, chemotherapy. You are now in remission. It is now gone. You have rung the bell. The office is celebrating. We are back. Dante is back in the office. He is healed from prostate cancer. Okay, great, wonderful. But Dante's been out for a lot of period of time because of all those treatments. Well, the position comes up for me to I can get a higher position, get promoted. And I'm qualified, so I'm going to apply for this position. I don't know. You know, Dante's a great employee, but he had that cancer. And this position, we need people to be in place. So his cancer may come back. And so I don't know. It's discrimination. But I don't have cancer anymore. But because there's a record of me, and because I happen to be a current employee, they're trying to use that against me. And that is illegal. Another example is being regarded as having an impairment. If I have asthma and I work in a construction company, now I have asthma, got my little inhaler, but I'm one of the best employees. I haven't requested any type of assistance. It's not affecting me doing my job. Hey, I'm doing the thing. So now another position comes up, same scenario. Well, this is a physical, job. He may have a problem with it, but I didn't request an accommodation. I didn't next assistance. It's doing the same job, just at a higher pay, different level. What's the problem? So, various different perspectives on disability when we're looking at a complaint being filed. Marital status. How many of y'all even heard that marital status was a protected class? Oh, look at y'all. Oh, Edge and McKay did. I like that. Well, that good. Well, good. Most people haven't. So I'm glad that you all here. But I want to highlight marital status is not who you are married to, but is the state of being married. That also includes being single, separated, divorced, and widowed. There was a complaint that we did one time that this wife was saying because she was married to a specific elected official, they wouldn't hire her because they don't like her husband. Unfortunately, that is not covered. It's not who you're married to, but just the fact of you being married. Now, marital status is one of those specific statutes that's covered in the state of Florida only. So, you cannot go to the federal government to file a marital status complaint, but our office, we handle those complaints, and we do a full investigation. Now, again, I want to highlight the fact that even if it's not covered by the federal government or if it's a state-only claim, does not weaken your complaint. The federal and state label is only for the purposes of if you want to go in court, and then that's a conversation between you and your attorney on what options that you have available to that. So I don't want you to think of the federal government as high or low, because we're partners. Okay?
What would be an example of discrimination?
A marital status? Okay. You come into my job and you want to get hired. Okay. So, are you married? Okay, you're married. Okay. So you're coming to the job to seek hiring. All right. Great candidate and everything. This job requires a lot of traveling. You know, I don't know if your husband wants you to be gone that long. You know, it's going to be long nights and you're going to be overseas sometimes and you can't take your husband with you on these trips. So, you know, this might be for someone who don't have that responsibility, because I don't think your husband wants you to be gone that long. That's none of your business. If I'm applying for a job, hire me because I'm qualified, not because you think my husband won't like. That might be the reason why I'm trying to get this job, so I need a break. And it's a paid break. And also sometimes it's a free trip. So my husband, come on, let's go, baby. We can go to California. So that'll be an example. Okay. Then we have retaliation, taking adverse action against an employee for engaging in a protected activity. Hear me. You have the right to complain that something is not being done correctly on your job. The employer does not have the right to punish you for making that complaint. The employer does not have the right, for those in the back, on the other side of the Civic Center, the employer does not have the right to punish you for making a complaint, even if they feel like you did it fraudulently or because you're trying to get at them. But here's the thing that I have to highlight. It's not a matter of you just making a complaint. The retaliation has to be pertaining to one of those protected classes that we just covered. Now, if you're making a complaint because I'm loud and I'm just going to say what I got to say, and if you don't like it, you're just going to have to deal with it, you may be retaliated against, but that's not covered. So, it's under context. And I tell people all the time, until you actually file the complaint, we're really not going to know the undertone aspect of what happened. You're not going to be able to call our office. You're not going to be able to call the federal government office and try to explain to them in 30 seconds or 5 minutes. So do you think I had a case? We're going to tell you the same thing. File the complaint, and let's see where it goes. Because 9 times out of 10, if you say it over the phone or try to do it in writing, there's always going to be something that's missed. So that's why the investigation has to take place. 2 sides to every story. All right. So what is our EEO complaint process? Real simple. We review the complaint, it's investigated, and we issue a determination. Determination is a fancy word for we give you an answer, and it's going to either be a cause or no cause. That means there's reasonable cause to believe that discrimination took place, or there is not reasonable cause to believe that discrimination took place. So, For the Florida Commission on Human Relations, for our agency, if you've been harmed, you must file your complaint within 1 year or 365 days from the last date of harm. Let me help you all out on something that I tell a lot of complainants and they don't like to hear. If you're given a letter on January 1st and you're told you're being terminated on January 31st, your date of harm is not January 31st. Your date of harm is January 1st. Your date of harm is when you have been made aware that you have been harmed, even if the actual action is going to happen in the future. So even if you get a letter January 1st saying we are terminating you on June 1st, June 1st is not your date of harm. You were made aware on an earlier date. That's free. Please take that. Tell it to your friends, your neighbors, your loved ones. That kills a lot of people when it comes to their date of harm, as far as filing complaints and being untimely, for us just to take it in. Now, again, if you file a grievance, the question was, what if you file a grievance? Then that would be an adverse act. That's another action. Then we would use that date. And that's why we say, go ahead and file the complaint and get all the information so we can look into that. All right? Once your case is actually into the office, we're taking it in, you have been notified that, yes, we're going to investigate it. We are statutorily required to investigate your cases within 180 days. Full stop, no exceptions. We have to investigate your case. If we do not investigate your case is automatically closed and you are given the right to go to court. Caveat, if your whole intent was to go to court, you can't go to court unless you file with administrative agency, either the EEOC or our office. We come in, I want justice, I want to get him, I want to take him to court. Well, that's great and wonderful, but you have to file it with us first. Well, why? Because the law says so. If you want to go to court, you have to file through us. Now, with our agency, we have to investigate in cases. And they'll be thorough, they're going to be intense, getting all the information, but for our agency, that is what we're required to do. Here's another thing I love to highlight, and my fellow colleague, Carlos Borges, could definitely attest to this. If we receive a complaint or you want to file a complaint, please file with only one entity, either the Florida Commission on Human Relations or the EEOC. Do not file with both. Otherwise, we end up with what's called duplicate investigations. And what we don't want is one agency says there's cause, other one says no cause. Because either side is going to say, we support that side because it's going to benefit them. Now, fortunately, we have a great working relationship with the EEOC, so we're in constant communication. Do you have this case? Yes, we have this case. Great, cool. We're going to knock this out. Hey, you need to contact the other office. Question.
So then is it all based on who's studying the case for you guys to get to different conclusions if it's all the same information presented?
Yes and no. There are a lot of different variables and factors when it comes to investigations. We all have the same law, but as far as how it's being reviewed, also what information has been given, being accessed to. Most of the time, and my colleague can attest to this, for whatever reason, sometimes they'll give different information to different agencies. And I've never understood that. So if we had that same information, we probably made the same conclusion. There was a situation where we actually had an example where that happened. And the main crux that we were trying to figure out what to do was like, okay, well, this is not good. And the main crux when we looked at the case was our federal partner had sufficiently more information than we did. Like, well, duh, we would have came to the same conclusion. So that's why we try to discourage and frown upon. Now, one of the things, as I said, we have a partnership with the EEOC. What that means is, because of our partnership and our relationship, when you file with our office, your federal and state rights are covered, provided that you meet the federal guidelines. Your state guidelines, they're going to be met. But there's certain criteria for your federal rights to be covered are going to be met there. So that's the reason why we say, please don't file with both. Because one, if it doesn't meet the federal guidelines for them, it'll come to us. Now, there is no better or worse. Let's be clear on that. It's a preference, and everyone has their different reasons for that.
So does the EEOC only, do they only investigate the federal side of things? And they kick it down to you for state?
They only kick it to us state because they can't cover it. So if they can't cover it, then they'll give us a, hey, this is outside of our authority, or the term is jurisdiction. You all take a look at it. And then we'll look at it and say, yes, we can, or no, it's outside of our jurisdiction. So now, I would like to encourage everyone that even if our office or even the federal government can't look at it, that doesn't mean that it's dead end all per se, depending upon what the situation is. It may be a situation that is our agency just can't cover it, so you may go straight to court. Ding, ding, ding. You want to go to court anyway? There's your lane. But it's a case-by-case scenario on that. So, and you won't know until the case is filed. Now, I'm sorry, I missed.
Is one agency faster than another?
It depends. It really does depend. It depends upon the complexity of it. It depends upon when the case is filed. There are so many different factors on how fast a case goes. I can only speak for in terms of what our state agency, what we're mandated to do.
Or based on the data that you know? Go ahead, tell me.
No, it's really case by case. There are some cases that I personally know they filed with the federal government, and then 2 months later they had a determination. So, and I can't speak to the process as far as the EEOC, as far as how, because I'm like, how did y'all get that done so fast? You know, so I can't really speak to it. It's really a case by case scenario. And I know people don't like that answer, but that's an honest answer. It is a case-by-case scenario. When you get a case in, depending upon the complexity of it, depending upon what's being asked, there are certain things that comes into the case. Oh, I need this information, this information, this information. The respondents quickly respond to it. I get that information. I get my interviews. I get boom, 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 boom. I got to answer. Other times, it might be I need to go back and forth, back and forth. So it really depends upon what that actual complaint is will determine how quickly. And then also the internal process.
You also mentioned you guys only had 60 employees, where Feds would likely have a whole lot more. So would that make a difference?
It does. It can make a difference, but we got to be, as far as us, we got to gallop. We can't. There's a lot of different things that maybe the EEOC may have a little more flexibility in doing, as far as allowing certain time frames. Like if some, for example, if a company said, we need a 60-day extension, no. That's probably not going to happen. Whereas the EEOC may allow that. So, like I said, it's really a case-by-case scenario because our time frames are shorter. And even though we try to operate similarly, we're beholden to, our state law. So that's what makes that difference, for that. How many cases we do? I know we take in between 11 to 1,300 a year. That's coming in. Now, are all of them processed? No. But we do have to look at each and every one of them. Our hands touch those numbers to determine, yes, we can take it, or no, we don't take it. And the question was, how many does the agency take in a year? And that does fluctuate. And depending upon what's going on, it may highs and lows. Develop that. Interesting enough, take a guess, what is the number one basis that you think is probably investigated? I heard age, I heard race. Anything else? What is the number one basis you think is filed within the state of Florida? Race and age have been okay, so y'all just gonna say all of them just to make sure? Y'all ain't smart. Y'all. Retaliation. Okay. Disability is the number one basis filed in the state of Florida. Guess what number two is? Well, y'all said all of them, so Retaliation. So while everybody thinks it's race and gender, which goes back to my conversation at the very beginning, what is discrimination? Everyone thinks race, race, race. We have to change that concept. Discrimination is not just about race. I said I'm gonna have a shirt. Discrimination, not just about race, because everybody in here, you all can be discriminated against. I had a caller call, and they said they talked to some agency, I don't remember when, they said, because I'm white, I can't be discriminated against. I said, I'm sorry, so they lied. Yeah, I said those words, sorry, they lied. Anybody can be discriminated against. So that tape recorder that Mr. Caldwell was talking about, that needs to stop. Anybody in this room can be discriminated against because of any of those protected reasons, and can be discriminated for more than one. There are many complaints that almost every one of them were checked off. I'm like, why are you even working there? So yes, you can be everybody can be discriminated against. The matter is, was it unlawful on what they happened? Because perception is reality. A lot of times, because we have limited information, all we know is what's happening to us. And based upon, I was treated this way, she wasn't treated this way, it's gotta be because I'm a guy. Mr. Bonner, she has a master's degree, she's been doing this particular job, you haven't done any of it. Oh, I ain't know that. But that's what happens a lot of times. So don't feel bad or like, because all you can go on is what you see and what you know. Now, don't buy into the office gossip as well, because that can also sometimes not get you in trouble, but kind of make you look stupid. Because you only have some of the information. They only told you this part of the information, but they didn't tell you, yeah, but she got a master's. Yeah, man, they just like, what did Mr. Caldwell talk about? I love his opening plenary session. She is the favorite. She likes it. That's why she got the position. Don't know the fact that I don't have a master's. So a lot of times people get gaslit. But on the other side too, your harm is your harm. And don't let anybody minimize that as well. So if you feel like you've been harmed, file the complaint. It's free. It doesn't cost you anything. You do not have to have an attorney to represent you. The attorney is only there just to give you guidance. Having an attorney that's not going to speed it up either. My name is Mr. Bonner, Esquire, and I'm filing this complaint on behalf of Miss Jane Doe, and I expect for you to process this case immediately. Mr. Bonner, thank you for filing this particular complaint. You're going to be at this particular line, but I'm Mr. Bonner. Yes, Mr. Bonner, we appreciate you filing the complaint. We'll look into it. Please get in line. So prestige has no factor when cases are being investigated. Last point of our process, cases can be appealed with the Division of Administrative Hearings. You don't have to like what our decision is. So there is an appeal process. So it's not the end all be all. And if you don't like their position, then you can go to the District Court of Appeals. You're finally now at court. So there is an appeal process. So it's not the end all be all. But before you get there, you got to start at the beginning. You have a question, sir? Oh, okay. All right, so we covered the EEO law. So we are taking a landing now, gassing up. Now we're going to talk about the Americans with Disability Act. ADA, commonly known as what everyone's familiar with, established July 26, 1990 and amended in 2008. This statute also includes emotional and support animals. We're going to talk about that. I'm so sick of seeing these doggies in Walmart. We're going to talk about that. Y'all may not like it, but we'll see. Now, when we're talking about ADA, it's actually divided into 4 sections. I thought it was important to know this because most of the time, ADA is a very broad federal law, and it covers all aspects of life. But that doesn't mean that the Florida Commission on Human Relations addresses all the different aspects of ADA. So the 4 areas are employment, ding, that's in Florida Commission on Relations. Public entities and transportation, not us. Public accommodations and federal commercial facilities, not us. And telecommunications, what's that? There you go, see? Y'all went to school. But we cover employment area. Now, in broken down as far as the different areas, there are different coverages by the statute. That's why I said ADA covers every aspect. You have agriculture, education, employment, Florida Commission on Human Relations, health and human services, housing discrimination. We're not talking about that. That'll be in the next panel this afternoon if you want to hear about housing and discrimination, that what we cover. Labor and workforce participation, land resources and environment, transportation, and other governmental functions such as public safety, courts, forensic hospitals, state licensing board. So ADA covers every aspect of it. But for the purposes for this agency, we only deal with employment and housing discrimination. So when we talk about disability, we talked about it in terms of physical, mental impairment that's substantially one or more life activities, have a history record of impairment, and is perceived by others. So we kind of addressed that already. So when a complaint is filed, we have to establish the first thing. Does the employee have a disability that substantially limits one or more major life activity? This is such a fancy word, major life activity. What is major life activity? Life, living. Would walking be a major activity? Would driving be a life activity? Is playing my computer a life activity? I call it playing, some people call it working. Any action, that's life activity. Now, if I broke my ankle, am I disabled? Oh, I love this. What does the caption say? A disability that substantially limits one or more life activities. When we're talking about the disability, we're not talking about on a temporary basis. You're not disabled for 6 weeks. You are disabled in the terms of the technical term disabled, like I can't do that, but having a disability. That's for a long time. It's important to know that. Also, you as the employer have to be subjected to any adverse action. Hiring, firing, transfer, any type of negative action. And then, employee has to be a qualified individual able to perform the essential functions of a position with or without an accommodation. Here is where we start getting a little bit rocky. Just because you have a disability, you have the right to get that job. However, can you do the job that's being asked of you to do with or without accommodation? Now, when we're talking about an essential function, essential function is basically the tasks that are fundamental to performing the position. And also to keep this in mind, an employee cannot be denied a position if they're not qualified. Excuse me, an employee cannot be denied a position if they cannot perform the marginal job functions if they are qualified to do the essential functions of the duty. So, I am the mail clerk. My job is to get the mail, to deliver the mail, and put it in the mailbox. Okay? So, I hurt my back. So, I can't lift the mail cart. So, can I fire that person because they can't lift the mail cart? Oh, very good question. Does their job description require them to lift that? I heard some other comments. Speak up, speak up. Yes, sir, in the back.
So I really wish that it were that simple, but it's not. um, you know, what happens when in our day-to-day, we know that technology is taking over a lot of stuff and a lot of functions, a lot of tasks. And so what happens when somebody's out for an extended period of time or somebody's disabled? We have a new software in place that's going to make us more efficient. Hey, this software is a little bit too complicated. I don't understand it. So it's part of, let's say, making sure transportation is correct or so forth. So when it's a little bit more nuanced than that, what happens when you're elderly or disabled? What, as an employer or somebody who needs to get the mission performed, what are my answers? What are, you know, trying to look at an answer for that situation.
Well, you bring up two different points. First of all, elderly cannot be used as an excuse because, like as we stated before, some of our more senior employees can do the job better. It is really a case-by-case scenario. Now, when it comes to someone who's disabled, it is the company's responsibility to make sure that person with an accommodation can do the job. But before that can take place, the person has to acknowledge that they need an accommodation. What an employer cannot do is just assume that because you have a disability, oh, you need some assistance, so let me go ahead and do. Did I ask you for that? So you're being regarded as. So there is a term called the interactive process. How many of you all like tennis? Okay, that's fine. I love Serena Williams. I'm sad I didn't get a chance to see her play live. She has a powerful serve. But the game doesn't start until what happens? She's got to serve it. Then the person on the other side has got to do what? Got to hit it back. That's what the interactive process is. The person who has the disability has to say, hey, I need an accommodation. So with the gentleman's example in terms of if I was able to do the job, so now something else is coming up that's interfering with my disability, I have to let the employer know that I'm having some difficulty doing this because of my disability. So I got to let them know. So then it is now the employer's responsibility to then respond in a timely manner on how they can be accommodated. Now, the interactive process is basically hitting it back and forth. Or it's like a dance. It takes two to tango. An employee just say, I need to be accommodated. Respondent says, how? I don't know, I just need to be accommodated. Okay, well, what about this? No. Well, what about this? No. You're not giving me anything to work with. Or, I need to be accommodated. I need someone to be able to lift this box. I can still do the mail, but I just can't physically lift this. Okay? So we go back and forth until we can resolve the complaint and meet the needs of the individual. So when you're talking about, in your example, as far as technology is concerned, it depends upon what the disability is that a medical provider is certifying, saying, first of all, they can't do a specific function, and what will it take for, what is the accommodation that can be done. Now, to the young lady's point up front, what does the job description says? Because the accommodation that may be requested may be a marginal position that maybe it can be absorbed someplace else. Or if it's an essential function, that's what needs to be accommodated. And you're going to go back and forth until you can find out what can be met. Yes, ma'am.
So I actually have a great example of the mail, just because I happen to know people that work in the mail, so I'm glad you said that. So there's a person, they're over the age of 50, and I'm no spring chicken, but it's not that they can't lift the package, they can't throw the 2,000 packages a day they need to throw. There's no accommodation that can be made to that. I mean, you can't stop 2,000 packages from coming into the post office. They have to be thrown, and that's her job.
Again, it goes back to one, is the person have a disability? And is the disability tied to their particular job duty? Otherwise, you are making an assumption that because of their age, they can't do the job. Also, if the person does not state that they can't do the job, then the employer is within its right. If the requirement is for that day, I'm supposed to throw 2,000 packages at the end of the day. That's the policy. Everyone is required to do that. If they don't adhere to it, the employer has a right to write them up, discipline them, because that's in the policy. That has nothing to do with who they are as an individual. It has to do with what's in the position. The job position, in what you have stated before, if it's in, I'm supposed to do this particular process, then you're covered. But if you're talking about a disability, you as the employer have to bring that to their attention so we can engage in this interactive process. Otherwise, that person will be disciplined based upon the policy, not because of their characteristic.
So it's kind of like a weird situational question. So let's say you have multiple of the same position, right? And someone makes an accommodation and says, I need assistance in this area, and they put the work upon another employee that is younger or in another area. Can they use that as discrimination in a way, or file a complaint as discrimination for them putting the work on them now just because of the accommodation of another person? Or would they have to find another area to provide that accommodation in?
That's a tricky thing. There's a lot of factors that takes place. It depends upon what the job duties are. It depends upon what the requirements are. It depends upon what the workload is. Because an employer does have a right to disseminate the work as they see fit, as long as it falls within the job duties and requirements. For example, there was a situation of an employee years ago where their responsibility was to deliver packages, but they don't deliver packages to this one section. So the needs of the organization changed. So now instead of just one department, they had to do to all departments. Well, they alleged, well, no, I'm only supposed to do this particular this section. Well, your job position description said it just deliver packages. It didn't say only to this position. So the needs of the agency changed. And that's the thing to understand. That's why it's a dance. That's why it's a going back and forth. Depending upon the needs of the organization at that time, duties and responsibilities and workload may change. If I'm an investigator and I'm so used to only investigating 10 cases, and then now I get a dump of 100 cases, that's not right. Well, the needs of the organization have changed. And unless there is a protected characteristic, the reason why it was done to you, then it's applicable to everyone. Gentleman in the back.
I think you said earlier that a disability requires it to be long-term. If this employee's temporarily hurt his back, is he protected under the disability rules?
It depends. The reason why it depends is because even though disability may not play a there are other laws and also in your organization that it can be covered. For example, if you were providing a temporary accommodation to someone else but didn't provide a temporary accommodation for you, that could be a reason for you being treated differently as well. So again, there's nothing cut and dry. There's always various different factors. Most of the time, because if you're dealing with FMLA, that's also a process of it. If you're also dealing with the work policy as far as the state of Florida, as far as state employees, they have state leave. There's certain things that they're able to offer as well. Also, past pattern and practices. Mr. Caldwell's talking about that favorite individual. I love that example. If you allowed it for one employee, you got to do it for all. So some people, they always fuss about having seasoned employees that's been there for a long time, but they know some things. And especially if the same management has been in place. So based upon that, a lot of times there are parameters, for that as well. But that's where the doctor's information comes into play to be able to facilitate that particular need. Question.
Reasonable accommodation. So can you talk about, because I've always thought it was a reasonable accommodation. So for example, a person is qualified, they have a documented disability. I, as the employer, have to provide a reasonable accommodation for them to do the essential job functions that they can do with this reasonable, with an accommodation. But the accommodation that would work is way out of my budget. I don't have the budget to get the accommodation that they need in order to do that. How does that work?
Okay. Reasonable accommodation still falls within that category. Reasonable is not just based upon what the employee, but also with the employer. There is a thing called undue hardship. It's a high standard, but it can be met. And also, when you're talking about reasonable accommodation, if you can't do that particular thing that's outside of the financial aspect, is there anything similar that can be done to still do the same job? The other thing about reasonable accommodation, which happens to be the next one. Did you see my presentation? I'm going to jump to this part right here. The accommodation cannot put the employer under undue hardship. And the accommodation doesn't have to be precisely what the employer requested, but cannot be less effective. One of the misnomers of reasonable accommodation is you got to give me what I asked for. That is not true. The accommodation has to meet both the employee and the employer's need. So in your example, if the accommodation request is something that it can be proven it is way beyond your ability to do it, that can be considered an undue hardship. However, the question is there anything else that you can look into to do the same job? Because reasonable accommodations do not have to be traditional. Think outside the box.
And the onus is on So the employee requests
A $2,000 something or another that's going to help them be able to do this. I look at the budget, I don't have it, and I don't anticipate having it, but I see that there are these other things out here, so look at these and see if these will work.
Then what you have just done, you have participated in the interactive process. You said, hey, we can't do it like this, but these particular things we're able to do. You've now shifted it back on the complainant. It is now the complainant's responsibility to say either this can work, this can work, this can work. Now, if they say, no, it can't work, there's a little dance in terms of why it can't work. You just saying no, why? Either it doesn't, it's going to exacerbate my condition. It's, just saying no for the sake of no, then you have to show that you have done your part. Because that's going to be the question. What have you done to facilitate this? Well, we did this, we requested this. And then also make sure you're doing it in a timely, fashion as well. You have a question, comment?
Just making sure to your question, Sika, that undue, a lot of people will put in like a monetary amount. I will tell you the courts have had zero when it comes to like a government entity because they say you have access to that. So if you come back and say, now if it costs $2 million, you would probably have to err on that's an undue hardship. But if it's $2,000 to buy some software or things like that, then the courts have looked at it and said, maybe so. But if you found something that's a cheaper alternative, or if you've worked with an organization, I know I do Ask Jan, and I'll Ask Jan Job Accommodation Network, listing of jobs, and you document that process, then when you do have a complaint that comes through, you've documented the process and you said that undue hardship and this is why, and that person's come back. Now it's basically your story as an employer versus the employee's story. So that's the undue hardship. That's the way I look at it as an HR person.
Very, very good point. The thing is, we have to document it. And also, were you able to find something that was comparable to that particular thing? Again, not less effective, but it can still do the job that is required to do. And then also, the employer can request medical information to affirm the fact of they do have that disability. Don't have to get into the details, and everyone does have access to that. But the employer just gonna say, employee just, I have a disability, and okay, well, we need some documentation to support that. Also, the documentation, the accommodation request has to be tied to your disability. It can't be, I have a disability, something for my feet, but it's with my head or it's with my arm. The disability has to be tied to that. And that's for the doctor information between the HR or your legal, whatever, whoever handles your HR, portion. Again, like I said, the accommodation does not have to be traditional. There is an interactive process, and it has to happen within a reasonable time frame. Reasonable is very subjective. So, and it's always going to be a case-by-case scenario. If it normally takes 30 days to get a response, and that's your traditional policy, it's not going to reflect as far as the employee. They took too long. Well, the policy says they have 30 days, and then you waited a week, and you're trying to file a complaint. So that's something to be considered as well. Real quick, because I'm moving out of time. Service animal. Service animal is a dog.
I'm sorry, because I just have been thinking about all these different service animals that we've seen online, and that just caught me off guard, because I wasn't expecting it to be defined as a dog. So I'm sorry for that.
Oh, you're fine. A service animal is a dog. Dog. Scooby. Snoopy. Not Garfield. A dog that is individually trained to do work or perform tasks for a person with a disability. Only dogs and miniature horses, don't ask me why, I do not know why. It's in the statute. I can't answer that question, so don't ask. don't ask. I don't care. I can't answer that question because I don't know.
But your statistics don't match. A service animal is a dog. Only dogs and horses are service animals.
Well, this was just an extra part I wanted to highlight. But for the most part, it's a dog.
Or miniature horse.
Yeah, so I had to make that correction then.
Okay, I'm just making sure.
Yes.
Okay, sorry.
I appreciate that. I take constructive criticism. I'm good. I'm a big boy. State and local governments, business props, nonprofit organizations that service the public must allow service animals to accompany persons with disability. So, service animals are dogs that's tied to their work or performance to do a disability. Now, businesses hate this, but businesses also have rights too. There are two questions that a business can ask an individual when they come in with a dog. Number one, you have the right to ask, is the dog a service animal? Number two, this is what most people don't like. They can ask, what does the service animal do to assist with your disability? They can ask those two questions. Not what the disability is, or where the dog is trained. Very good. So, girl, you need to come up here and do this part. They have to ask. They have the right to ask: is it a service animal? And what is the task? What is the to assist with the disability? That'll determine whether or not it's a service animal. There is no law that says that they have to have documentation, certification. I know a lot of people would like that, but unfortunately, the government hasn't decided to upon that. But those are the two questions that an employer has the right to ask.
So they don't have to have a documented disability with the employer. employer.
No, this is talking about in general with as far as doing a service animal. There's a question in the back. Yes, sir.
So they can ask, but after asking, what happens? What if the answer?
If they give them the answer, they have to accept it and move forward with that. Most of the time, if they don't give you an answer, then the employer can basically say, okay, because if it's a place where you don't just get pets, I'm sorry, we're going to have to ask you to leave. But if they say if it's a service animal, you got to back up. Now, if that service animal acts unruly and causes a disturbance within that business and organization, you do, as an employer, have the right to ask them to leave because they're causing a disruption. Because a service animal is supposed to serve to assist. A service animal is an extension of the person. Touching a service animal is like coming up and touching your arm. And for women, you can appreciate this. It's like someone just coming and just touching your hair randomly. If you don't get away from my hair. It's the same thing. So when someone says, is this a service animal? They say it's yes. You got to let it go. And that's when you just go walk away like Fred Flintstone. Back 'em. They shouldn't have the service animal. That's because that's a personal thing. Okay. Emotional support animals. There is a difference between service animals and emotional support. Emotional support animals are used for medical treatment, provide companionship, assist with anxiety, depression, and certain phobias. Any animal can be an emotional support animal, and training is not required. Hold on. Hush. Moment of silence. Let that drop. A question in the back.
So you told us if they claim that it's a service animal, we got to back off. Now you're telling us that any animal can be an emotional support. So what if I ask, is it a service animal? They say, well, actually it is.
Okay. No. I mean, I can answer the question. I'm trying to make sure I'm not leading. The main thing I want to highlight the fact there is a difference between a service animal and an emotional support animal. That's the first thing. Okay. And when we're talking about ADA also covers public accommodations. So, service animals are going to assist with, if I have a heart issue, most people can handle the CNI dogs and, those type of things. It's the ones where they see Fifi in the little cage and it's got the little tutu, in the buggy, and, like, why are you in here? And I'm trying to get my broccoli here. That's where people have the issue. Okay. So if it's a service animal, it has to be a dog. That's the clearest aspect of it. Most of the time, this is what we're dealing with in the public, is the emotional support animal. And it can be any animal. However, emotional support animals are not considered ADA, and so therefore not covered. Emotional support animals are not considered service animals, so therefore they're not considered with ADA. The problem is the fact of employers it's in a very gray area. And so most of the time, employers just try to tread lightly and not enforce, as long as that animal does not cause a commotion or cause a problem, they say, you know what, just let it ride. Because we're dealing with nuances concerning that. Because there's certain things that that's covered under the ADA that emotional support animals can be, places that they are legally to be in, and other areas they're not. But that we're going to get into the splitting of hairs. And that's why most employers are like, no. And I bring this up because you can have a service animal at work. You just can't bring your cat because a cat is not a service animal. But the service animal has to be tied to the disability. And then the service animal is also an accommodation to be able to do the particular job as well. Yes, ma'am.
So, say that I am a person who suffers from depression. And that severely stops me from doing my job, and I need my emotional support animal. But you're saying it's not covered by ADA. What happens to me? Because I need my squirrel at work.
Well, the problem is because of the fact it's not covered under the ADA,
That's helping me with my squirrel at work.
but it's not covered under the ADA.
Okay, better example. Better example. You have animals, dogs mostly, but there are some animals they have now investigated that can detect, I have a seizure disorder, I have type 1 diabetes, I have whatever it is that might cause me to seize, faint, do whatever. So those would be classified. And normally they're dogs, but I've seen where there are other animals that are being trained on how to deal with me to make sure I don't hurt myself if I faint and all that. So are those service animals? Because I see medical treatment, which is the diabetes and the seizure disorder a disability or is it a medical treatment? And therefore, is my animal a service animal or is it an emotional support animal?
It can be both. But it goes back to the default of what a service animal is. A dog or a miniature horse. So if it's not one of those two, it is not a service animal. It could be an emotional support animal, but it's not a service animal. So again, when we're looking at different criteria, what the standards are, it's what's the first prong? What's the second prong? So if we're talking about a situation where they feel like they were denied their animal, the first thing, is it a service animal? That's a yes or no question. So service animal is basically dealing with a dog. Okay. And to assist with all of this information, these are some of the resources. Of course, you can go to our website, fchr.myflorida.com. You can also go to ada.com, EEOC.gov, HUD.gov. One of the participants talked about JAN. You have askjan.org. And then you also have SHRM, Society of Human Resource Management, SHRM.org. Those are also different resources. 5 minutes. Okay. Ooh, I got 5 minutes. This has been good. Some quick nuggets. One, making sure we establish neutral, objective criteria to avoid subjective employment decisions based upon personal stereotypes and biases. Second, make sure all internal policies are followed consistently. Everybody. Don't do it for some and not the others, like the favorite employee, Mr. Caldwell says. That's going to get you in trouble. Make sure all employees are aware of your policy changes at the same time. Please don't let electronics know and janitorial service don't know. Don't do that. Please. Dissemination of information should not be based upon what section you are working in or what your favorite section is. Just trying to help you out. Train all levels of management. I should have bolded that parameter. All levels of managers and all employees on EEO laws. Implement a strong EEO policy that's embraced at the top levels of the organization. The laws won't work unless all management is in alignment. And that's something that as a response as state and federal agencies, we're trying to get management to understand. Promote an inclusive culture and workplace by fostering an environment of professionalism, respect for personal differences. Foster open communication and early dispute resolution. Move quickly with your investigations if a complaint is filed and update the grievant on the progress of the investigation. Perception is reality. If a person has filed a complaint, if you file a complaint, please don't wait an extensive length of time to get back to them because they ain't doing nothing. And you could actually be doing something. It could be just simple as, hey, just update, we're still working on your case. I have updated you. I ain't got to be detailed. Document. Come on, say it. Document. What did I just say? All actions of your employee and inform them when they are being disciplined. No gotchas. And also, as an employee, keep notes, keep records. When I was first hired 25, 26 years ago, one of the assistant directors said, baby, document everything. Because you just don't know. And I've carried that with me. Also, HR needs to review all recommended disciplinary actions and collaborate before implementation of an employee. That's just to make sure there's a 360. So if you work in HR, check with your legal counsel check with HR to make sure all aspects are covered. And management isn't always right. In the back, in the Civic Center, management isn't always right, including senior management. Get your ego out of the way. I don't care if they made you mad. Did they break the policy? Then you follow the policy accordingly. Otherwise, you get yourself in hot water. We've asked a lot of questions. Any final questions? Because I think they're trying to tell me it's time to wrap up. It's time. I don't want to keep y'all from eating. Thank you so much. And if you have any additional questions, come and see me in the back. Thank you all so much. I hope I added a little bit to your brain cells.